Hello, all of our friends out there in the YouTube lands, the interwebs, or whatever we call those. Welcome to the show today. Yes, I'm a few minutes late. Um, I need to get with my team and discuss what time I'm planning to do this regularly. I always think I say 1 or 1:30. But I think I mean that for Central Time. But when I'm scheduling it, I set it for my time, and that's not what I intend to do. So we'll figure this out together as a team, and then we'll, uh, I'll try to do better about that. But I'm not confused about the time, but I, well, maybe I am confused about the time. So anyway, we are going to talk today about Daniel's appeal. And along with that, I want to talk about uh, the secret hearings that they kind of play hand in hand. So um, hang on, I'm getting a message I need to respond to somewhere. Maybe, oh, okay. Yeah, I'm having the same issue, Cherie. Cherie is joining us, but she's having mic issues, and so am I. So, anyway, Rick, do you mind kind of while I try to fix my doggone audio issue, perhaps talk a little bit about what we're going to be discussing in the appeal, or we can wait for me to get my sound going. Rick is
Well,
back. I
there's
think he's feeling better, so I'm going to let him kind of get started with what we're going to talk about with the appeal and um, some of the important issues with it.
yeah, his appellate attorney. I'd love to be able to sit down and talk with this appellate attorney.
I
I it's
or, you know,
it's a well
oh,
written petition. It really is. There's like seven, seven different propositions that he makes in the appeal for why it should be vacated or retried.
yeah, I'll go ahead and bring it up on the screen, and we can share it on the screen. And we're not gonna read all of this, although, like Rick said, it is a really good. I mean, I agree. I think it's a pretty good brief, but it's about I don't know, probably about 68 pages, 60 pages perhaps, is all that it really is.
With
But
the appendix, I think it's 73 or something like that.
yeah, yeah, table of contents and all that, everything. Yeah, it's like 73 or 74 pages. But the meat is what we're going to kind of pay attention to here. Um, and if I can find it, we won't be, well, where's my window? I'm having struggles today, and I don't really understand why, because there's no reason for it. I mean, there's just no excuse for the struggles, but for whatever reason, I'm having them. Um, I told Rick I've started eating better lately, and my body might be in shock, or my brain might be in shock. I don't know, but for whatever reason, I'm really struggling to share some stuff here and to get my audio. My browser blocked my screen. Click the screen icon in my address bar to allow access, then reload. What the heck? That has never been an issue before. Why are you doing that? Okay, I'm not sure why it's blocking my screen. Why is that? I don't even know what that means. Um,
I have no idea.
I don't either. What I've been able to share my screen just fine before. And you know what, you guys, I always am feeling horrible about how how long it takes me to, that I struggle with getting this or getting that or whatever. And I've been watching a lot of other channels lately because um, I'm watching the Lori Vallow trial and try, trying to watch the Karen Reed trial too whenever it decides to get going. I think they still have a few more jurors to choose. But anyway, so I'm watching, just kind of flipping through other YouTube channels. And you know what? I'm not the only one who struggles with sound issues or screen sharing issues or whatever. So I think I'm okay. In the meantime, Cherie has popped in. How are you doing, Cherie? There we go.
I'm doing pretty good. I am just Rhonda though right now, so there's
Are
two of
you?
us.
Is it? Oh my
I,
God.
well, I was in a hurry signing in the second time, so I may have missed a step. But
Okay.
here I am.
But you okay. Well, you shouldn't you didn't sign in with the link though, right?
No, no. I don't know how it happened. I can leave and try again if you guys want to get.
No, you're fine. You're fine. I'm trying to teach Cherie. Cherie is my team member, I guess you would say, on my Streamyard. And okay. And
Not very techno.
yeah, she and I both together are not techno. And when you put us both together trying to be techno, it's funny. Anyway, so I'm trying to teach her how to, and she was doing it last night. She's also a team member on someone else's StreamYard, case by case. And so before we got her over on case by case's StreamYard panel, I thought I showed her how to, be. I want it to be so that Cherie can star comments and questions for me and put, highlight them on the screen and things like that. And we're really struggling to get through that, but it's okay. We'll figure it out. So that's part of my monologue for the day. So I want to go through really quickly and say hello to everyone. TJ is in the house. TJ, it's great to see you. I hope you're doing well. And Just Dawn, how are you doing, Just Dawn? More here is also here. And oh my goodness, More here gifted 10 memberships to some folks in the chat. So thank you so much again, More here, for your gift of memberships and for helping others to be able to enjoy um, the gifted memberships. And I have a few more emojis to make for our channel, but we'll get some more emojis made. And I'm not lying, not gonna lie, I am struggling to get some membership videos and stuff put together, but I'm not ignoring it. I'm not forgetting it. I'm not trying to avoid it. I'm just, for somebody who doesn't have a full-time job, who's retired, I'm so busy. I can't seem to get to it. Mose, it is great to see you from, I believe, Pennsylvania. I hope that you're doing well. I hope Mrs. Mose is also doing well. Please tell her hello for us and tell her that we love her. And you guys are always welcome in our chat and, in our hearts. So thank you so much. Um, and like I said, Just Dawn. Oh, yep, there's Cherie pretending she's me. I don't know. We'll figure it out. We'll play around again another time. So we'll get it figured out. And TJ says, "Congrats to the winners. I have confirmed that the odds are one in number of subscribers, so 1 in 740. I have 740 subscribers. That's amazing. I'm so grateful for that, and I appreciate that so much. Um, so yeah, feel free to invite all your friends, all your, not your enemies, but people who who are interested in true crime or wrongful convictions, corrupt trials and things like that. Please invite them to come over and check it out and see what we're doing with Daniel Holtzclaw's case. Marjorie. We call it a we call it boomering when Joe does it. Yeah, I know. And I am a boomer and I'm proud of it. And I I used to do some of this stuff really well, and I had gotten very comfortable with it, but Streamyard has updated their software so much, and there's so much improvements. There's so many benefits now that we can use to use in using Streamyard. I know it's no competitor at this point with OBS, but Richard from Off Label Podcast is determined, generously offering to help me with OBS so that we can get started with I can start streaming via OBS. But I'm pretty comfortable with well, I'm not even really comfortable anymore because of all the features and updates, but I feel much safer with StreamYard at this point. So TJ says, I put the Z film on my channel, just found out through the comments open top convertibles don't have windows. Oh wow. Yeah, that's could have been an interesting day for you, an interesting drive. So yes, yeah. I'm glad that you're getting better every day, and I don't know all the circumstances around what's going on, but you definitely will remain in our prayers, you and Pam both. So thank you so much. Okay, so I managed to get the brief in here, and what I'm going to do is, like I said, we don't want to read the whole thing, but Daniel's appeal attorney was James H. Lockard, Michael Moorhead, and they were the attorneys for Daniel in his direct appeal. So, like I said, we're going to go through this really quickly. That's the table of facts or table of contents. What I will do, though, and if Rick and Cherie want to share with me, I think Rick said there were like 17. I think he's right. That's what I remember from going through it this week.
Seven,
but I think
7 propositions.
Okay.
Yeah, 7.
So how about we each read a couple of I'll read the first 2, and then Rick, if you want to read the second 2, and then Cherie the third 2, and then I'll read the last one. Does that sound okay?
Yeah, that's fine.
Okay. So these are the propositions, the 7 propositions that Daniel had proposed in his appeal. Proposition 1: the evidence was insufficient to prove the charged crimes. There was no evidence that the alleged procuring lewd exhibition occurred in public view, nor was there any evidence that the alleged rape and oral sodomy counts were accomplished by means of the use or threat of force or violence. And the evidence supporting the sexual battery counts was insufficient to allow any rational trier of fact to find the defendant guilty of those offenses beyond a reasonable doubt. I concur. Proposition 2: plain fundamental error occurred when the state of Oklahoma was allowed to prosecute 36 alleged crimes against 13 separate women who supposedly did not know each other in one trial, encouraging the jury to convict appellant based on an aggregate of the evidence presented rather than adequate proof of each individual charge. Rick, 3 and 4?
Yeah, it's...
Can you not see it?
Yeah, no, I see it. I've got a hard copy in front of me.
Oh, okay, that's right. Okay.
The circus atmosphere that pervaded throughout this trial deprived appellant of a fundamentally fair trial consistent with due process of law. It was insane. You've heard Rhonda talk about the atmosphere around the courtroom before. It was absolutely crazy. Appellant's rights to due process and a fair trial fell prey to overzealous prosecutors who shifted the burden of proof to the defendant, argued facts not in evidence, and improperly disparaged opposing counsel, flagrantly misrepresenting the evidence and prior argument. For anybody that saw the video Rhonda did, what's it been, like 2 weeks ago? The talk that Giger gave to the
Oh yeah, a
court
couple weeks ago.
reporters
Yeah.
thing.
Yep.
He talked about opposing counsel like that all the time and outright lied and made false statements. It happened during the trial too.
Yeah. Yeah, it did.
I think I have a different word for him than overzealous, but okay.
Well, you know,
Oops, I lost
you're
my...
a lawyer. You know you're supposed to try to be nice and things that are in black and white.
Civil.
Sorry, I accidentally...
The ethical abuses violated the appellate's due process right, absolutely shifting the burden of proof, arguing facts not in evidence, which was the crazy part about that is not only did they would say something correctly about something that was in evidence, and then later on argue something exactly opposite that wasn't in evidence.
Yeah.
They said two different things about the same thing. They gave two different explanations for it, and it's I don't know how they got away with it. I really don't. Disparaging defense counsel. There again, if you saw that talk he gave, you know exactly how he talked about Daniel's first attorney.
Yes.
And violated about 7 rules of ethics in the process.
Yeah, at least, right? At least. Yeah. And I will get that. I had to do some editing on the Notorious video that Rick is talking about. I'm gonna. Okay, this video is gonna pop up, and I'll get it off just as quickly as it pops up. But anyway, okay, sorry. But I'll get that edited. I hesitated to edit it because when you edit a video, once it's been uploaded, it takes away, it cancels out the chat, and I don't like doing that. Yeah, so what is happening here? Okay, let me get the screen share back up here really quick. Sorry. And then Cherie did you get your part finished? I'm sorry, Rick. Oh, yeah. Okay. All right. So Cherie is going to read propositions 4 and 5 for us.
Sorry. Appellant was deprived of the reasonably effective assistance of counsel guaranteed him by the 6th Amendment to the United States Constitution because his trial attorney failed to present available expert testimony pertaining to the DNA evidence, failed to object to joinder or request a severance, and failed to object to numerous instances of prejudicial prosecutorial argument. A, deficient performance, failure to present available evidence. 2, failure to object to joinder. 3, failure to object to prosecutorial misconduct. And then B, prejudiced. Proposition 6. Under the facts and circumstances of this case, the 263 years in prison resulting from the trial court's ordering all 18 individual sentences to be served consecutively amounts to an unconstitutionally excessive sentence.
Sorry, I muted myself. Okay, so that's been one of the... I need to study, obviously, the 8th Amendment because I've been screaming, the 8th Amendment, the 8th Amendment. And I'm told over and over again, it doesn't apply in the way I think it does. So, but the unconstitutionally excessive sentence, even people who have talked about, who believe Daniel's guilty or whatever, that, leave comments in chats and on videos and whatnot. even a lot of those people say that 263 years is very excessive. And I guess a lot of people base it on, some murderers who don't get that much time, or, child predators who don't get this much time, you know, or who, get with the possibility of parole and good time and all that stuff. And Daniel doesn't even have those options. I mean, each sentence that he's serving time for, each one of them will come up for appeals during, different times. I believe the first one that was I think it'll be 2 years ago this May. And that was the one where, for Tabitha Barnes, where I made the video clip that I've shown you guys 100 times. But, as time goes on, other charges and sentences will also come up for appeal, I'm assuming. Honestly, I'm just kind of guessing at that, but that's my assumption. But, I mean, when he appealed the first one with Tabitha Barnes a couple of years ago, it was very quickly denied. I don't know anything about what the parole board was thinking or where their thoughts were, but it was very quickly voted, they all voted no on him. And I don't know, I remember watching that, and I felt like, to me, like they were just like, okay, come on, let's finish getting through the commentary here, and so we can vote, because we already know we're going to vote no, was just kind of how I felt. That was just my opinion, though, of that. So anyway, yeah, the excessively, unconstitutionally excessive sentence was one of my biggest complaints. Okay, anyway, for Proposition 7, the accumulation of error in this case deprived appellant of due process of law in violation of the 5th and 14th Amendments to the United States Constitution and Article 2, 7 of the Oklahoma Constitution. And so then it kind of goes on from there. And then it lists, the appeal lists all of the case law that Daniel cited, which is, I think we got like 4 pages of case law. Of course, I haven't gone to all these case laws and read any of them at all.
Good luck doing that. There's 88 of them.
88, yeah, I knew there was a lot, that's a lot. Well, I'm not saying that that's an excessive amount or like, a lot compared to other cases. It's pretty common to have a lot of case law, but you use the case law to help you prove my simple terms, to help you prove your point in your whatever motion it is that you're filing. So, and then we have, of course, statutory authority, several Oklahoma statutes, Constitution amendments that were used, and then some different, I can't think of the word I was going to use, but anyway, so it looks very normal to me for any other appeal or any other motion that I've, looked at for any other person involved in litigation. But it just says, brief of appellant. This brief is submitted on behalf of Daniel K. Holtzclaw, the defendant in Oklahoma County District Court, who will be referred to by name or as appellant. Appellee will be referred to as such, or as the state, or as the prosecution, and then it gives instruction of how to read the different things. What I'm not going to go through is the statement of the case, because this is the part where they go through each accuser and what their different accusations were, and the charges and the counts and everything, and how much time they were, he was sentenced to per person. So I do. Okay, yeah, let me read this part here, the statement of the case. Appellant Daniel K. Holtzclaw was charged by information in Oklahoma County District Court, case number with 8 counts of procuring. So this is basically all of the charges that he was convicted of and being charged with is the word I want to use, with 8 counts of procuring lewd exhibition, 10 counts of sexual battery, 7 counts of forcible oral sodomy, 6 counts of first-degree rape, 2 counts of second-degree rape by instrumentation, 1 count of indecent exposure, 1 count of first-degree burglary, and 1 count of stalking. Oklahoma County Assistant District Attorney Galen Giger and Lori McConnell prosecuted the case. Appellant was represented at trial by Messrs. I have no idea what that means. Rick or Cherie, trial by Messrs. I don't know what that is. I mean, maybe somebody else does or doesn't. I don't know.
It's just a fancy way of saying more than one person, and you list all the names after.
Okay, thank you. So Scott Adams and Robert Gray, both of Oklahoma City, the Honorable Timothy R. Henderson presided over the trial. Appellant was acquitted of 18 of the 36 counts, but he was convicted of 3 counts of procuring lewd exhibition, 6 counts of sexual battery, 4 counts of forcible oral sodomy, 4 counts of first-degree rape, and 1 count of second-degree rape. The jury assessed a sentence of 5 years in prison for each of the procuring counts, 8 years in prison for each of the sexual battery counts, 16 years in prison for each of all but one of the sodomy counts, assessing punishment of 20 years on the remaining sodomy count. Trying to think of who that was. I honestly, off the top of my head, I'm not sure whose that was. I'll have to find out and try to get back with you guys on that one, unless one of you on the panel know for sure.
I'm not sure which one that was.
Yeah, I don't know for sure which one that is. I'll have to find out now. I'm curious because I hadn't realized that before. And then 30 years in prison on each of the first-degree rape counts and 12 years in prison on the second-degree rape count. The trial judge formally imposed judgment and sentenced on January 21st, 2016, ordering the counts to run consecutively for a combined total of 263 years. It is from this judgment and sentence that Mr. Holtzclaw appeals. And then this is where all the statements of fact go into each accuser individually, and we're not going to do that. So, but you can get this in the Discord, our Discord channel, or you can. I don't know. I haven't tried to upload this in a description box yet or anything, but I'll see if I can do that. But at any rate, you can certainly go over to the Discord and find it there.
That was Janie Liggins.
Janie Liggins. Really? So
Yep.
Now that's coming back to me. Janie Liggins, the first accuser, and I probably say this every time we do a live stream, Janie Liggins, the first accuser, who had 0 DNA evidence in her SANE exam or any place else. 0 evidence of the SANE exam. SANE exam is sexual assault nurse examiner. So just mind-blowing. She got the 20 years where everybody else got 16, and there was no evidence of any of this, honestly, but that's neither here nor there, but I mean at this point, but 20 years, and there was no evidence. Go ahead, Cherie.
No, I was just going to say when it's running through my head, which one it might be. She did not come to mind as the one.
Yeah.
Yeah, that was count 16.
Wow. Yeah, she didn't come to my mind either first, so it's insane. Okay, so those are just the very, very basics of the appeal that Daniel filed. And it was filed on February 1st, 2017. And then comes the strange, well, I don't even know how to describe it. So I think what I'm going to do is just go ahead and play these clips for you guys, these news clips. Nothing fancy on these news clips, and I will pause between each one. I think there's 5 or 6 perhaps. And I'll just pause between each one just so that I can avoid, hopefully, any kind of strikes by any of these news channels. So, and well, let me just say too, I got all of these. I pulled all of these off of Holtzclaw trial YouTube channel. That's Brian Bates has 2 YouTube channels. One is Holtzclaw trial YouTube, and the other one is, I think, Bates Investigates YouTube. These were from the Holtzclaw trial YouTube channel. So here we go.
An ex-cop appeals his sexual assault conviction. Daniel Holtzclaw is doing 263 years for sex crimes against women while he patrolled Oklahoma City.
And tonight, News 9's Lisa Monahan tells us he and his attorneys claim, among many things, insufficient evidence. Lisa?
Yeah, Daniel Holtzclaw's attorney raised that issue and several others with nearly 100 pages filed today, claiming he didn't receive a fair trial during the highly publicized case.
He simply had too many cards stacked against him that never should have been allowed in a court of law.
In the appeal, attorneys for Daniel Holtzclaw claimed the state had insufficient evidence, lumped too many crimes together, allowed a circus atmosphere. Also, prosecutors argued facts not in evidence. He had ineffective counsel, and the sentence is unconstitutionally excessive.
Finally, the Holtzclaw family can point to something in black and white and say this isn't just the family speaking. These are some very learned opinions from professionals that say that there were some things done that were extremely wrong.
Brian Bates began as the private investigator for the defense, and later the Holtzclaw family asked him to speak on their behalf, now in response to the appeal.
It covers just about everything that they were concerned with,
namely the issue of a circus atmosphere. Holtzclaw's attorneys claim publicity turned up dramatically during the 2015 trial due to the growing Black Lives Matter movement, with individuals taking pictures in the courtroom, protesting in the hallways, and even a victim testifying while admittedly high on drugs. The appeal also scrutinizes a key piece of evidence in the case, DNA.
Now we're finding out that DNA evidence very well may have been misrepresented. Some DNA evidence may not have been disclosed, and the prosecution's own DNA expert may have given testimony that was totally contrary to her own findings.
But Oklahoma County District Attorney David Prater responded, "I am confident the conviction is constitutionally and statutorily sound. Furthermore, I am confident of this convicted rapist's guilt." Now, I also reached out to the attorney representing the victims in the Holtzclaw case, but did not hear back in time for this report. Lisa Monahan, News 9.
There's a new development.
I keep muting myself because I'm loud and obnoxious and vaping or slurping coffee or whatever. So I mute myself and then I forget I'm muted and I'm just chatting away. Anyway, so that was as far as I can tell, at least from what Brian Bates has on his Holtzclaw trial YouTube channel, that is the first news report that we got after when the appeal was filed. So then what happened after that is, well, I don't know. To me, and it's hard for me to, because I feel so close to this case, because I've been researching it and studying it since I think 2020 or 2021. I feel like what took place next is so egregious and unconstitutional, but we're going to go ahead and start with those clips.
Against him that never should have been allowed in a court of law.
In the appeal, attorneys for Daniel Holtzclaw claimed the state had insufficient evidence, lumped too many crimes together, allowed a circus atmosphere. Also, prosecutors argued facts not in evidence. He had ineffective counsel, and the sentence is unconstitutionally excessive.
Finally, the Holtzclaw family can point to something in black and white and say this isn't just the family speaking. These are some very learned opinions from professionals that say that there were some things done that were extremely wrong.
Brian Bates began as the private investigator for the defense, and later the Holtzclaw family asked him to speak on their behalf, now in response to the appeal.
It covers just a
claim publicity turned up dramatically, protesting in the hallways and even evicting drugs. The appeal also...
Now we're finding out that DNA evidence, some DNA evidence may not have been disclosed, and the prosecution's own DNA expert may have given testimony that was totally contrary to her own findings.
But Oklahoma County District Attorney David Prater responded, "I am confident the conviction is constitutionally and statutorily sound. Furthermore, I am confident of this convicted rapist's guilt."
Now, I also reached out to the attorney representing the victims in the Holtzclaw case, but did not hear back in time for this report. Lisa Monahan, News 9.
There's a new development in a case of a cop convicted of rape. But here's the twist. The courts have ordered all details about it covered up. And as Fox 25's Phil Cross shows us, their curtain isn't just closing on the public's right to witness justice.
Our story begins here at the Oklahoma Judicial Center, where the Court of Criminal Appeals meets. Now, this is where the state is fighting to keep Daniel Holtzclaw in prison. Now, the state recently filed a motion under seal, which is uncommon but not unheard of. However, the court took it a step further and issued a protective order over all this new information and then kicked the case back to Oklahoma County. So here we are at Oklahoma County District Court. When we first asked the court here, they said the case was all with the Court of Criminal Appeals, so they tossed the legal ball back to the state's Justice Center. Here's where it all gets a little weird. The court is even keeping this new information secret from Daniel Holtzclaw's own attorneys. And when we asked what was supposed to be happening in district court, the judges in this building told us we had to go back downtown. We tried to ask Judge Timothy Henderson, that's him right there, about when this mystery information was going to be heard in his courtroom, but his office says he can't comment on anything related to the Holtzclaw case. So we asked when this hearing would be set.
Confident the conviction is constitutionally and statutorily sound.
So here we are back at the Court of Criminal Appeals, where we have prison. Now the state...
Good grief, that is really hard to pause and start and whatever. I apologize for that. I've messed with that and now I forgot why I wanted to even pause, but okay, I can't remember what I was going to say. Rick or Cherie, do you want to say anything before we start back on it again?
It's absolutely unconstitutional.
Yeah. Well, and Phil Cross says here that it's not unheard of.
No, I'm talking about them tossing it back and forth and putting a protective order on there, especially from Daniel's lawyers.
Yes. Yeah, for sure. Oh, yeah, that's the biggest. To me, that's, well, I don't know which one of the points is the biggest violation, but certainly the going back and forth and covering it all up and the fact that they did all of this for 2 days. These meetings took place over 2 days with no notification to Daniel's attorney or Daniel. And I mean, they talk about, and the victims weren't notified either. Okay, I'm just going to say this. I'm not concerned about the victims. They already got what they wanted. They falsely accused somebody of horrific crimes. I'm not concerned about the fact that they didn't get to be notified either. Not my problem. Don't care. But here we go. I don't know why this backs up automatically. I don't know what I'm doing wrong. Hopefully it won't do that again, but let's see.
Recently filed a motion under seal, which is uncommon but not unheard of. However, the court took it a step further and issued a protective order over all this new information and then kicked the case back to Oklahoma County. So here we are at Oklahoma County District Court. When we first asked the court here, they said the case was all with the Court of Criminal Appeals, so they tossed the legal ball back to the state's Justice Center. Here's where it all gets a little weird. The court is even keeping this new information secret from Daniel Holtzclaw's own attorneys. And when we asked what was supposed to be happening in district court, the judges in this building told us we had to go back downtown. We tried to ask Judge Timothy Henderson, that's him right there, about when this mystery information was going to be heard in his courtroom, but his office says he can't comment on anything related to the Holtzclaw case. So we asked when this hearing would be set. His office says he can't comment on anything related to the Holtzclaw case. So we asked if the public would be allowed in the public courtrooms during this hearing, and well, you guessed it, his office says they can't comment on anything related to the Holtzclaw case. So here we are back at the Court of Criminal Appeals, where we asked the judges why the need for all the secrecy and the legal justification for that, and also how that squares up with the oath they took to uphold the U.S. Constitution, which allows for public access to the courts, and the Oklahoma Constitution, which also allows public access to the courts. Here's what they had to say. Oh, you didn't miss anything. They didn't respond. So here's what we do know. The Oklahoma Attorney General's office, which is handling the case now, says the secret information is just that, a secret. They won't talk about it, except to say the district court will be holding an evidentiary hearing on the matter. Now, the Oklahoma County DA's office, which is not involved in the case anymore, says this new mystery information does not include new details dug up by the AG's office and does not include any allegations of wrongdoing by county prosecutors. So far, no court or agency has been willing to say why all the secrecy is needed or been able to provide the legal justification for keeping the public out of the justice process. Phil Cross, Fox 25 News.
That is how you tell a story. Now, secrecy is becoming quite common since Daniel Holtzclaw's conviction. His information was deleted out of the Department of Corrections offender information site, and the agency won't say what prison he is at, even though every other prisoner's information is in that system.
Okay, so that was the beginning of learning, well, the public learning, I guess I should say, that there were secret ex parte meetings taking place about Daniel's case, and the judge claimed he can't say anything about the Holtzclaw case. I'm just curious if he can't, well, I mean, I know what he's saying. He can't say, and he can't talk about it, blah, blah, blah. But he was very quick to seal all of the records of this secret meeting or ex parte meeting. And still to this day, those records are sealed, and I get the very, very, very strong impression that they will never be unsealed.
Oh, probably not.
Yeah. I mean, I guess that's not a violation necessarily of of constitutional rights. Honestly, I don't know.
It is if you are keeping them away from his attorneys.
Yeah. So there you go. And his attorneys don't have, well, at least to my knowledge, they don't have, those records are still sealed, and nobody has access to the sealed records of this hearing that took place regarding, from the way I understand it, and Cherie or Rick, you can correct me if I'm wrong, please, but from the way I understand it, regarding, well, I know it was regarding testimony from somebody who testified in his trial, and the fact that Campbell Ruddick is part of those meetings. Campbell Ruddick is the, I know supervisor is not the correct word, or neither is manager, but he was in charge of the Oklahoma City crime lab at the time that this evidence was tested and testified to. So because Campbell Ruddick was a part of those meetings, it leads me to speculate that it had something to do with testimony given by Elaine Taylor. I don't know that. That's just my
I'm sure
assumption.
with him being involved, I'm certain that that was part of it.
Right.
I've just always been of the opinion that more than one thing was discussed.
Sure. Oh, for sure. I mean, yeah, that makes sense. 2 days worth of meetings. Yeah, I can't imagine that it was just that. The city attorney, his name is Richard or Rick Smith, or I just shorten it down and call him Dick Smith. You know, just because, I mean, that is a nickname for somebody named Richard. Anyway, but he is very much a Richard, in my opinion. But he was involved in it, and so was Chief Deputy Johnny Coleman. And I mean, I don't know. I just feel like there must be more than just, like Rick said, more than just DNA discussions being had in those meetings. But I don't know. That's, again, my assumption. So we're going to go ahead and can continue. And here we go.
All new at 9, new clues about the secret court hearing in the case of a cop convicted of rape.
Fox 25's Phil Cross got the surveillance video that shows who all took part in the secret hearings that even the defense wasn't allowed to attend.
The hearings happened this week. They began Monday when the prosecutors with the Oklahoma County DA's office arrived just before 9 a.m. Galen Giger, the head of the DA's Public Corruption Division, who also led the prosecution against Daniel Holtzclaw, was there. One of the witnesses, Oklahoma City Deputy Chief Johnny Coleman. He was in with prosecutors and the judge for more than an hour. Also present, a senior city attorney who handles civil litigation. The hearings lasted all day Monday and all day Tuesday. The AG's office, which is supposed to have the case now that it is in appeals, could only tell us the hearing was an evidentiary hearing. The DA's office has not returned our multiple calls, texts, or emails related to these hearings. However, when Fox 25 first broke the news about the secret orders issued by the Court of Criminal Appeals, DA David Prater said the issue had nothing to do with any wrongdoing by his office or his prosecutors, but said he could not say more. The videos also confirm Holtzclaw's defense attorneys were not present, and Fox 25 has learned they were not even told about the hearings until after they were over. Phil Cross, Fox 25 News.
Daniel Holtzclaw is serving his more than 200-year sentence for multiple sex crimes, including rape. His appeal is stalled at the Court of Criminal Appeals until whatever was discussed during the secret hearing is decided.
Okay. You know, they talk about an evidentiary hearing, and I'm not really sure. I mean, I know what an evidentiary hearing is, but I am unaware of any sort of evidentiary hearings in Daniel's case, at least where he was allowed to participate in, him and his or his attorney. So, an evidentiary hearing for who? For what purpose? I mean, these are kind of rhetorical questions. But to me, an evidentiary hearing is something that's awarded to a defendant, and I don't know this to be a fact, but strictly, but it's awarded to a defendant when evidence has been shown to be when it's been shown to a trial, to a court, that there is evidence of somebody's innocence that hasn't been looked at yet, or hasn't been presented, or part of a litigation or adjudicated. So I'm unaware of any such hearing for Daniel in Daniel's case. Anyway, so that was one of the other news clips that played during this time. I believe that one was on June 30th. Remember, the appeal was filed, I think it was February 1st. And this is now, we're into June, and then we'll move into July and into August.
Oklahoma City. Fox 25's Phil Cross was the first to tell you who was at the secret proceedings as part of the Daniel Holtzclaw appeal.
But what does that mean for the case? And what does it mean for taxpayers who are footing the bill for both prosecuting the former cop and defending the city against civil rights complaints? Tonight, Phil Cross gives us a closer look at a Fox 25 follow-up.
In prison for what is likely the rest of his life, former police officer Daniel Holtzclaw maintains he did not sexually assault, rape, or do anything inappropriate with the women he was convicted of assaulting during traffic stops. He's appealing his sentence, but the state has held secret hearings about key information that could impact his freedom. Only no one from his defense team was allowed to attend.
He's on pins and needles. He wants to know, is this good news? Is this bad news? What is it?
Brian Bates is one of Holtzclaw's most ardent defenders. He worked on the case as an investigator and now operates a website in defense of Holtzclaw.
I don't care what side you come down on whether or not Daniel is guilty or innocent. What people need to be aware of is this could happen to them eventually. They could find themselves in the crosshairs. There could be secret hearings going on. There could be things being discussed that are going to affect your and your family's life, and you're not going to have any input.
Thanks to surveillance video from outside the secret hearing, we know the two-day proceeding included a team of prosecutors and the deputy police chief, along with Oklahoma City's chief civil attorney. The city attorney said he wouldn't comment on his role at the hearing, whether he was there to testify or acting as an attorney for the police department. The victims in Holtzclaw's case are suing Oklahoma City, which means the hearing could either hurt that case or create new legal problems for OKC if it is focused on wrongdoing to Holtzclaw, which is what those who have followed the case the closest believe.
If you're asking me to guess, I would say this is obviously in Daniel's favor. The prosecution has circled the wagons. I can guarantee you, if any of this information was negative to Daniel, they'd have sent it out in a press release.
But even for those convinced of the criminal conviction, there was another party kept out. The victims, who say they were sexually assaulted, were also not allowed inside that hearing that could impact their lives. And the public, which pays for everything from the prosecution to the light bills that keep the courtroom illuminated, is left in the dark. Phil Cross, Fox 25 News.
Okay, so that was Phil Cross's. I think it was this particular report. There was actually, I played from two different news channels. It looks to me, well, I don't know if the other channels, I know there's a channel 4 in Oklahoma City, but the ones that Brian Bates has on his YouTube channel, Holtzclaw Trial, were from Fox 25, I think it was, and KWTV, which was channel 9. But anyway, both of them had a report on the same topic that one day, so I played them both. But anyway, again, Phil Cross, because he's a journalist, and in my opinion, the only fair journalist, honestly, at least from news clips I've seen of regarding Daniel's case, the only fair journalist, or open-minded one, I guess, non-biased, was Phil Cross. But like I said, I only saw a few of his reports, so I know some of the others were. Anybody from the Oklahoman, I guarantee, is not going to do any favor in Daniel's direction whatsoever. But that's a whole other story. Anyway, so that was another report from that channel. We're going to move on to the next report. I think this one might be the one that moves us into August. I might be mistaken, but we'll see.
The Oklahoma County DA's office has not returned our multiple messages about the case, but in the past they have told us the new information has nothing to do with allegations of wrongdoing by the DA's office or prosecutors involved in the case.
I was mistaken. This one's still July 3rd. This is Channel 9's coverage, I think, of the same story.
Information surrounding the appeal of Daniel Holtzclaw, the former Oklahoma City police officer convicted of sexually assaulting women while he was on duty.
Now, last week we learned there had been an unusual closed hearing in district court, really raising questions about where the case is headed. Our Lisa Monahan has been digging for answers and even spoke with Holtzclaw himself today. Lisa?
Yeah, Amanda, I was able to get an interview with Holtzclaw from his prison cell today, but that's not all. In an effort to understand what this hearing was all about, I requested surveillance video from inside the Oklahoma County Courthouse near the judge's chambers.
The doors were locked, the public shut out of Judge Timothy Henderson's courtroom. Surveillance cameras capture a team of prosecutors, including the lead in Holtzclaw's trial, arriving ahead of the proceedings. Not even Daniel Holtzclaw or his defense were privy to information discussed during the two-day secret hearing. Now, for the first time, we're hearing from Daniel Holtzclaw in his own words, responding to the secrecy surrounding his appeal.
I'm extremely upset about it because for my trial was unfair advised, and still to this day it's that way. There were 2 full days where the secret hearing was going on and my lawyer wasn't allowed to be there, let alone know about it. Also, the lead prosecutor in my trial who lied gets to weigh in on a response or have his input. How is this in any way, shape, or form fair to me? Not only should I be able to know what's going on the public, but the public has to know as well. If I was a hardworking taxpayer in Oklahoma, I'd be irate. I would be knocking on doors and trying to find an answer. More importantly, for the audience out there listening, this can happen to you, and my case can happen to you.
A court order prevents the lead prosecutor and others Holtzclaw mentioned from responding to his allegations, and the reason for his case being returned to trial court remains a mystery due to documents filed under seal. However, surveillance cameras captured witnesses, including a civil attorney for the city, a Deputy Chief Johnny Coleman, and OCPD's forensic lab supervisor, Campbell Ruddick.
I've never seen anything like this, so it's something significant.
Scott Adams represented Holtzclaw at trial and says based on the people present for the hearing, it would be reasonable to assume it's related to the lab that provided DNA evidence in the case. But he says he can't fathom a scenario that deserves this level of secrecy.
Now, Daniel Holtzclaw opened up on several other issues, including DNA evidence that's become a focus of his appeal. I'll have more on that tomorrow at 10. In the newsroom, Lisa Monahan, News 9.
Okay, basically another report of, the same thing. And as it goes on, you can hear these reporters, these news reporters talking about, or at least addressing the fact that this is really strange, unethical, if nothing else, behavior by the state in general. David Prater, I have a video that I did a couple of years ago, way back sometime, where I kind of did like a, introduction to all of these people involved with the state. And David Prater, I believe I did one on David Prater. He is one of the most angry, hateful, bitter seeming men that I can remember seeing as part of Daniel's case, but not just part of Daniel's case, but just as him, as the DA for Oklahoma or Oklahoma County. He is just always seems angry and confrontational and combative with every topic that he is in front of the media about. Even when he's smiling or thinks he's won a thing, he just looks hateful and mean and bitter. And he was all about making sure that the state made sure that Daniel was going to be convicted. So clearly they did. Here we've got a couple more to play. And for everybody in the chat, I'll go through the chat after we're done and address comments and questions. So I'm not ignoring everybody, but I just want to get through these news clips.
I have a prepaid call from
Holtzclaw.
an inmate at correctional facility.
Daniel Holtzclaw claims he was railroaded. The former Oklahoma City police officer has insisted he did not commit the sexual assaults he's convicted of.
Well, now a secretive closed hearing on Holtzclaw's appeal is raising questions about the case and has Holtzclaw concerned enough to speak out from prison. He spoke on the phone exclusively with our Lisa Monahan.
We wanted to hear firsthand from Daniel Holtzclaw what his attorneys and others are trying to argue in his appeal, their belief that the DNA evidence that was key in convicting him was flawed.
I was flabbergasted.
Daniel Holtzclaw remembers his reaction when he heard investigators had DNA evidence supporting the allegations against him.
I thought that, they were setting me up. I thought something was tampering of evidence. I was like, are you serious? I didn't do anything sexual in nature with any of these women, so where is this evidence coming from?
The DNA sample linked to the youngest of 13 accusers was relatively small. In his appeal, Holtzclaw contends a secondary transfer rather than direct sexual contact is the explanation for these findings.
So it was unfair. I didn't receive a fair trial.
More recently, a group of forensic scientists with no connection to the case requested the appellate court hear their concerns about possible misuse of DNA evidence in Holtzclaw's trial. The scientists claimed OCPD's forensic analyst reached a flawed conclusion that sexual contact explained the DNA found. That analyst, after nearly 30 years with the department, retired 3 days after Holtzclaw filed his appeal. The appeals court refused to hear from those scientists last month. Around the same time, the case was sent back to district court for an undisclosed reason.
There were some very underhanded things that were done regarding DNA.
Brian Bates was a part of Holtzclaw's defense team at trial and remains his advocate.
The rumor is that these secret hearings have to do with DNA. Something about the DNA, we don't know.
During the 2-day closed hearing, courthouse surveillance cameras captured the witnesses called, including an OCPD forensic lab supervisor. A court order prevents any of the involved parties from talking to us, but Holtzclaw believes this is further evidence of a conspiracy against him.
It's not innocent until proven guilty. You gotta prove yourself innocent and then find your feet, fight for your freedom.
Daniel Holtzclaw was convicted of 18 sex crimes against 8 women. He was sentenced to 263 years.
Okay. I know this sounds like it's all repetitive and you keep hearing the same thing over and over, but I want you to keep hearing this same thing over and over because it's outrageous. Everyone should be bothered by this, if not more. I'm incensed by it. I can't think of a word that's more fitting to how I feel about it. But yeah, I want to keep playing the same context of these reports. Because I want you guys to keep hearing them. Because it's so outrageous to me and illegal to me, unethical, I guess is a better term. because until they get caught or charges get brought, they're just these people in Oklahoma, from detectives to their supervisors to DAs and dirty judges. Again, I know I've said this a million times, but just want to also have you remember this as well. Judge Timothy Henderson, who presided over Daniel's case, who held these secret hearings or secret meetings, ex parte meetings, without Daniel's knowledge or his attorney's knowledge, is the same judge who back in 2023, I believe, April of 2023, was forced to resign because of serious sexual assault allegations made against him from two females in the district attorney's office, and then at least two defense attorneys, on the outside of the DA's office. This is the same man who sentenced Daniel Holtzclaw to 263 years for crimes that I am slowly but surely trying to prove to anybody, all of you here, and anybody else who will watch and listen, he is 100% innocent of. I don't like to say not guilty, because to me there's two different things. Not guilty and innocent are two different things. So I always try to remember to say innocent. Okay, anyway, here we go.
New at 10, the mystery surrounding another ex-Oklahoma City officer's legal troubles is mounting. The Court of Criminal Appeals filing more motions under seal in the Daniel Holtzclaw appeal. It's one our Lisa Monahan has been following closely since the court held seemingly unprecedented secret hearings. Lisa?
Well, Kelly, we've been digging for information on these hearings for nearly a month now. The court transcripts, the judge's ruling, and even the order that asked for it all to be sealed is now sealed too. And while the court probably has its reasons for keeping all of this information confidential, the lack of transparency is really raising a lot of questions.
The problem I see is that it lends credence to the public not trusting in what's going on.
With that in mind and the Oklahoma Court of Criminal Appeals policies in hand, we went after the protective order filed with the court clerk, the one dictating all of the secrecy in Daniel Holtzclaw's appeal.
The court sealed that order. Normally that order is not sealed, but the court in this case did seal it.
We pushed back because the OCCA rules state even when the information is sealed, the protective order shall be accessible to the public.
Rules, they're written by the court, and the court can override their own rules.
It's just an oddball, everything seems to have not.
Now, these employees are not the authority, but Court Clerk Michael Ritchie was not there when we stopped by. He did, however, tell Holtzclaw advocate Brian Bates something very similar.
The court sealed it because this is a very touchy. I'm Mike Ritchie, the clerk of the court.
Bates says he posted the recorded conversation to social media to incite public outcry demanding transparency.
I want some answers, and I think that it should be very eye-opening to all Oklahomans when you try to follow the rules and the court makes up their own rules as they go along.
Legal analyst Irvin Buck says the rule seems pretty clear, so the court must be trying to protect someone or something questionable in the case.
And the idea that if it says public access and you can't see it just makes people more suspect of what's going on.
Now, no one knows the next step here or if there will be another closed hearing, but we were told to check back here tomorrow. Of course, we'll do that for you. Live on the scene on the story, Lisa Monahan, News 9.
So Irvin Box is I don't really know very much about him other than the comments that he made regarding these secret hearings. And then another case that he makes some comments on for an attorney who was a criminal, I believe. Cherie, was he a criminal defense attorney, Alex? I think he's a criminal defense attorney. possibly.
I can't remember. Who are you talking about? Alex?
Alex, yeah.
I think he was, but I can't swear to it.
Yeah. Yeah. So this is Alex that we're talking about, Alex Bednar. He was fired. Listen, I'm not even going to try to start with his case because it's crazy. It is crazy wild. But from what I know about his case, which is it's even more twisted and wrapped than Daniel's, if you can believe that. But he was fired from being, fired and I don't know who fired him, fired and barred from the Oklahoma County courthouses. And there's a story out there where he went anyway into to try a case or whatever it was he was doing, and ended up in big trouble. But anyway, Irvin Box, the older gentleman you just listened to at the end, commented on that case as well. And he also talked about when Judge Henderson, former disgraced Judge Timothy Henderson, was forced to resign. I didn't pull up the quote. I wish I had, but I didn't. I didn't even think about it until just right now. But he made a comment about how that Timothy Henderson, once he was found out or accused, that between Henderson and David Prater, the DA's office, and other attorneys and judges in Oklahoma County, that Irvin Box says it was a, what was the phrase he used, Cherie?
I remember like a well-known secret or something like that.
Yeah, a well-known secret that all of this sexual misconduct stuff was going on between the judges and these attorneys and you know, all through the DA's office and everything else. I don't know, maybe if I can I know I can find that clip. It'll just take me some time, but I'll have to find that in regards to Timothy Henderson, and I don't know, maybe make a, I don't know, I'll get it to you guys somehow, because it's really interesting what he says. And a few weeks ago, we, I think Rick and Cherie shared an article about big pimping in Oklahoma City, and it goes right along with that, what Irvin Box said. Anyway, so when Irvin Box speaks, I kind of do pay attention. I feel like he has a whole lot more credibility than any of the attorneys representing the state of Oklahoma. So I think there's just a couple more that we'll do.
The veil of secrecy is lifting, if even only for a little bit, in the highly unusual case of the appeal of a convicted cop.
Daniel Holtzclaw has been kept in the dark, and the state is asking whether or not they should be able to turn over material that could bolster his claims that he was wrongly convicted. Fox 25's Phil Cross first revealed the secrecy in this case. Now he tells us what the new records show about the case.
In court documents, the Court of Criminal Appeals first said the public had no right to see. The case is called unusual. That's putting it mildly.
Very mild term. I've never seen it in my career. I've yet to find another lawyer or a judge that's seen anything like this.
Scott Adams represented Daniel Holtzclaw in his initial trial on charges he raped and sexually assaulted women while serving as an Oklahoma City police officer. He does not have anything to do with the current appeal, but has been kept in the dark just as much as the attorneys that are. Newly unsealed records reveal the state found information that could help Holtzclaw, but the court has yet to rule on whether or not it will be turned over to the defense. The Attorney General's office cites an exemption in the Open Records Act about personnel records, indicating it was a personnel action that led to the discovery.
During that matter, they apparently found some information that is extremely important or exculpatory in regards to Daniel's case. They're using that as an excuse not to turn over that information, and they're trying to get the judge to say you don't have to turn it over because you found it in this personnel matter.
Fox 25 has previously reported on the secrecy surrounding Holtzclaw's case, and that a secret 2-day hearing involved questions about DNA and the DNA expert who testified at Holtzclaw's trial.
His constitutional rights, Daniel's constitutional rights, override any of that. And if there's anything exculpatory out there under the United States Supreme Court cases, it's got to be turned over to the defendant.
The court records say the witnesses, including the head of the DNA lab and the deputy chief of police, were thoroughly examined. But they were only questioned by the prosecutors and a judge. There was no cross-examination, and there is an attempt to continue in secrecy.
No matter what happens now, to me, the Pandora's box has been opened, because eventually we're going to be able to dig in here and figure it out. It may be years, but we're going to figure out what's going on here.
Problems with the Oklahoma City Police Crime Lab has the potential to impact hundreds, if not thousands, of cases. Emails obtained by Fox 25 already show a concern about the need for retesting of DNA evidence due to the situation surrounding a former lab employee.
We've seen it before, and we obviously didn't learn any of our lessons from what happened with Joyce Gilchrist.
Ultimately, no matter how you feel about the Holtzclaw case, this is going to affect you, the taxpayer. Taxpayer funds have already been used for the secret hearings, and if there's a new trial, it will cost even more. And that doesn't even take into account the emotional impact on those who say they were victimized by Daniel Holtzclaw. Phil Cross, Fox 25 News.
Holtzclaw's attorneys are also asking the court to stop Oklahoma City from destroying more evidence related to the problems in that DNA lab. Now, the court called Fox 25's reporting on the matter unsubstantiated, but asked the Attorney General to weigh in before they issue a ruling.
Okay, I think there's only one news clip left. Clearly, in my opinion, the more the media dug into this, the more they could report that there was a lot of nobody ever said the word corruption on any of these news media reports, but I'm not a journalist. I'm not a professional. I'm just going to say corruption. They're reporting this corruption. I don't know. Rick or Cherie, is that too harsh of a word to call it corruption about these hearings?
Nope.
I don't think so either.
I can't understand why. This was all being exposed in 2017. We're almost 10 years later now from just that, the secret hearings, and we still don't get to have any information about what was said in those meetings, other than the media did manage to make pretty legitimate, in my opinion, assumptions or beliefs, even Daniel's attorney and Brian Bates, for that matter. Even they believed that it had something to do with the the forensic testing done in Daniel's case. And for those of you who have been here for a minute watching the channel, you may remember that Elaine Taylor is the person who did the forensic testing in Daniel's case. Elaine Taylor is also, at the time, was also the mother-in-law of one of the detectives, Rocky Gregory, and her son is also a Oklahoma City police officer who took part in the first accuser's investigation briefly. But he was, I'm trying to think, was Brian Taylor part of the civil suit? Cherie, do you remember? I think he was, but I could be wrong.
So
I don't remember.
Kyle Bennett? I'm not sure about Brian Taylor.
Yeah, it wasn't Brian. It wasn't Brian Taylor. But anyway, yeah, Kyle Bennett. And anyway, but, and Elaine Taylor's daughter, who was married to Rocky Gregory, her name is Teresa Gregory. So Rocky Gregory and Teresa were eventually divorced, and she passed away. But that's those are whole other topics. But anyway, my point is that there was so much what I believe personally was conflict of interest just between the crime lab and the police department, with Elaine Taylor and Rocky Gregory, and it was never disclosed to the defense in Daniel's trial. But I believe Brian Bates uncovered that, and it did get brought up in the trial, but nothing came of it, of course. So having these, having these secret hearings, or secret meetings, whatever you want to call them, in 2017, and still nothing having come from that is really, it's really disheartening, disgusting, and to me is just more proof at how corrupt at least Oklahoma County is in the state of Oklahoma. And so I think we just have one clip left. I think it's just one. So we'll go ahead and listen to that now.
We do begin tonight with new information surrounding Daniel Holtzclaw's appeal.
He is the former Oklahoma City police officer, of course, serving life in prison for sexually abusing women while on duty. News 9's Tiffany Liu is live from the Court of Criminal Appeals with the very latest on this. Tiffany?
That's right, Kelly. Amanda, in my hand are the documents that were sealed and kept a secret until today. June 26th and 27th this year, a secret hearing was held in Judge Timothy Henderson's courtroom. Surveillance video shows who attended, but all the details were sealed.
The public wants to know what were the findings by this judge, and we yet have to find that out.
We only knew it was regarding Daniel Holtzclaw's appeal and that leaders of the police department's forensic lab were there. Today, though, new documents show the hearing was regarding a personnel investigation, which by Oklahoma law can be kept confidential.
I think it has to be in regards to Elaine Taylor, the chemist that was involved in this case and was central to this investigation as far as the evidence against Holtzclaw.
She's the former Oklahoma City Police Department chemist assigned to this case. Taylor retired days after the appeal was filed.
And now, is that a coincidence? I don't know. But then the second factor that's suspicious is that when News 9 applied to get her emails, those were deleted.
On July 5th, we requested for Taylor's emails from the city, only to be told they had already been deleted. Holtzclaw's attorneys are concerned those emails could be critical in the appeal, but the court order states those claims are unsubstantiated. Still, his counsel is worried additional evidence may be destroyed if swift action is not taken.
If there's something that wasn't done properly, if it's tainted, could this throw the whole thing out and start over? Yes, it could.
How Taylor's personnel file ties into Holtzclaw's appeal, if at all, is not clear, since the actual details of the hearing remain sealed.
The issue I have with the whole thing right now is the secrecy.
And of course, we're going to keep our eye out for any more documents that come unsealed. Reporting live on the scene on the story in Oklahoma City, Tiffany Liu, News 9.
Okay, that's the last that I could find on Brian Bates' YouTube channel. But honestly, I can't remember if there was anything further discussed about the secret hearings. So the email, there's got to be another video, because I know that, Cherie, do you recall another video, another news report of them magically finding, 4,000 of Elaine Taylor's emails magically reappeared after they claimed they were deleted? Or is that...
It rings a bell, but I can't be sure.
I can't. I might just be making that up in my brain. To be honest with you, it seems like there was some sort of revelation of some emails being discovered later.
I remember distinctly that they were quote unquote lost and gone forever, and then they appeared, or a lot of them at least.
Yeah.
But whether it was in a news report is what I can't remember for
Yeah,
sure.
I'll have to look for that this week and see if I can find if there was actually a news report. Because it's entirely possible I made that up because I felt like maybe there should have been a report. I don't know. But you know, I'll see if I can find see if there was a news report about that. And then report back to you guys to let you know. But anyway, I just wanted to share all of those news clips with you guys, and you know, the very basic brief of Daniel's appeal. And why was it? These are just rhetorical questions that I have. Why was it that after he filed his appeal? These are just things for you guys to contemplate. After he filed his appeal, why was there this, I don't want to say rush, because nothing really started happening right away, immediately, after he filed the appeal. But once it did start happening, and once these meetings took place, things went pretty quick about trying to cover up something, in the words of, well, of course, Scott Adams and Brian Bates, and I think even Irvin Box, that there was something they were trying to cover up. And to see all of those people, every time I could see those people walking into the judge's chambers or whatever it was, you know, like they just had, you can't really see it very well, but I just imagine what little bit I could see of their faces. I just imagine these little shit-eating grins on Galen Gigger's face. Well, when they show Gigger and Prater walking towards the judge's room, you know, they're laughing and chatting it up about something. But I just have this feeling like I can't shake the feeling that they were all sitting there with the judge. I believe they were having a serious hearing about something, especially with the crime lab manager, Campbell Ruddock. But at other times, I just have this, we will never know if there was any conversation about having to make sure that that this wrongfully obtained evidence or misrepresented DNA evidence or whatever it was. Pick your thing. I mean, you can pick your own, you know, unethical thing that occurred in the trial and insert it into that meeting. But with Campbell Ruddock, like I said earlier, with Campbell Ruddock being there, and then of course Daniel, Scott Adams, and Brian Bates, you know, also suggested, with Campbell Ruddock in there testifying about something, according to them, everything they discussed was about personnel matters, and that's why these records are sealed. Just it didn't make sense to me, because as far as I understand, we can, as members of the public, we can request some personnel information from any government worker, like, you know, getting how much they make a year. We can request how, you know, what their position is, their raises, their disciplinary records and things like that. Can't we legally request all of those things via FOIA and get it?
Well, it's either open records or FOIA. I don't know
which one. Yeah,
you know, which version they use in Oklahoma.
I'm not sure either.
But I mean, even under FOIA, you can you can request regardless. Whether documents are provided is, they can deny access to the records for various reasons. but they have
Right.
to tell you that they have documents, and this is the reason why you can't see them.
Why we can't release them? Yeah.
And regardless of whether the public, and I know we all agree on this, or everybody on the panel at least, that even if the public couldn't get the personnel records or whatever, Daniel still has a right to them, and because they obviously pertain to his case, and and if it was a personnel issue, usually that's with the people in the personnel department, not with the court and the judge. I don't know. That's what I see.
I agree. No, I agree completely.
There's a part of me that wonders whether the whole purpose of including her as part of the meetings was specifically so they could go, oh, well, it was a personnel matter and we don't have to disclose that to you.
Well, I mean, perhaps, but we do know that the media and Brian Bates tried to obtain the emails and they were denied because they said they had been deleted.
Yeah, now you're talking about records retention, and that's retention of government records and communications, and that's a whole nother rabbit hole that you can fall down quickly.
Oh yeah, for sure. But we can request, again, not always going to be approved, but we can also request emails between different members of our local and I guess federal government for that matter. We can request those emails. I mean, I've watched a lot of, not lately, but in the past, I used to watch a lot of auditor videos. I find them entertaining, to be quite honest, but it was rare to watch one of those without seeing one of the auditors, requesting emails between, so-and-so and so-and-so in a particular office or whatever. And, sometimes they would get them and sometimes they wouldn't. But the thing is, and I don't know about this kind of stuff, Rick, maybe you do, or maybe somebody in the chat does, or Cherie even probably knows, but so Elaine Taylor, the crime lab analyst who did the forensic testing in Daniel's case, she retired, I want to say, well, they've said it in several of the videos, several days after the appeal was filed, Daniel's appeal was filed. She wasn't set to retire for, I think, don't quote me on this time, but I think she still had another 6, maybe to 9 months before she was, I don't know if scheduled's the right word, but was expected to retire in another 6 to 9 months or something to that, something around that time frame. And, she ended up retiring months earlier than what she was scheduled to retire. Coincidence? Probably. I mean, I don't know. I'm not much of a coincidence. I don't really believe in coincidence a lot. I'm pretty much for the most part, I'm, black and white, really. I mean, there are some things where I have to find a gray area and settle on, but I'm not one for coincidences and I'm not one for gray. I just think a thing either is or it isn't. Is how I kind of feel about things for the most part. And so for her to, retire 6 to 9 months, whatever it was, earlier than what she was scheduled to retire, and right after the appeal was filed, and the appeal directly discussed DNA, flaws in the DNA evidence. I don't remember the exact wording. And even though I'm thinking that even though the Oklahoma Court of Criminal Appeals refused to include the amicus brief by the 6 renowned forensic I can't ever say what they are, but these very highly skilled and highly professional, world-renowned, people involved in forensics, they refuse to consider it. But I can't necessarily agree that they didn't read it, which I kind of feel like might be why they were in a bit of a panic. Just my opinion. They read this amicus brief by these 6, world-renowned professionals in forensics, and then they refused to consider it. And we didn't really read that. I don't know. I'll talk to the rest of the readers and the team, that I record transcripts with. Perhaps we can read and record that entire, I think it's like 60 some pages, that entire amicus brief, and play it for you guys sometime, because it's very, I just feel like it was very 100% credible. I mean, the professionals
It
that we
was.
are
I
aware
can
of,
tell you for a fact it was.
yeah, it's 100% credible. And the fact that we have Susanna Ryan and Brent Turley, who appeared for Michelle Malkin and demonstrated, how the DNA, Susanna Ryan demonstrated how the evidence, the DNA evidence was tested, was incorrect in Daniel's case, on Daniel's uniform pants. That demonstration that she did with Michelle Malkin, I thought, as a layperson, even I could understand that, and it made perfect sense to me that there was mishandling, is how I'm going to say it, of the forensic evidence in Daniel's case on the pants. So, to circle that all the way back to these secret hearings, and the appeal, and Elaine Taylor retiring, I don't know if it was suddenly, but it seems like it was sudden after the appeal was filed. And then learning that these secret hearings took place, and that in some way, shape, or form, DNA in the case had to be in question for Campbell Ruddock to be part of the hearing and to testify at the hearing. Whatever else, is, we can always talk about another time too, but listen, I'm just giving you my opinions, speculation. I'm not saying anything is factual but I do occasionally exercise some common sense and just, not having any real knowledge in any of those kinds of things, those topics. That's just what makes sense to me. And apparently I'm not off, I'm not that far off base, because that's what made sense to Daniel, his attorney, Brian Bates, Irvin Box, anybody but the state of Oklahoma. So, Rick, what else do you have about this topic?
I find it very convenient that the Court of Appeals kicked something back down to the county level that required the county court to hold an ex parte evidentiary hearing concerning a personnel matter. What is the Court of Appeals doing getting involved in personnel matters with local governments?
That specifically
just
had not
strikes me as
crossed
a
my
very,
mind.
very convenient excuse for why nobody can find out what was said.
Yeah. Yeah, I agree. I hadn't really thought of it in organizing the terms in that way, but that makes 100% sense again. And you know what's really frustrating about it when you said that out loud, Rick, is that I don't know if these entities just believe that the basic citizen is just dumb and unable to think for themselves and figure things out, or if they just are like, this is what we're going to say, we're going to stick with this story, and it's a hill that we are going to die on if that is literally what we end up having to do. And I can't imagine that they believe that this many people, including attorneys and, you know, forensic experts and things like, they have to know that the general public is just not that stupid, which tells me I think they must be saying, this is a hill we're going to stake our careers on, stake our lives on, and this is the hill that we are going to die on. Which is worse than just thinking that that we're just stupid, because it just cements the corruption and the unethical breaking of oaths, you know, that is just unimaginable to me. Cherie, what? Go ahead, Rick.
I just why would an appeals court look at an application for appeal and kick something down to a lower court? They had to have gotten something back. If they ordered the county to have that hearing, there had to be a response filed to their order. Or Shree, help me out. What's it called? Status report, status update, where the court orders something, and after a certain period of time, you've got to file some type of brief showing them where you're at in the process of following the order.
Is that like a status conference or no?
It's not coming to me right now either. I know what you mean, but they have status conferences to see where everybody's at, but I don't think that's quite what you're talking about.
Yeah, yeah, but usually there's a brief that's filed alongside in preparation for a status conference.
Right.
I haven't had to do that part of it yet.
Yeah, I'm sorry, I don't know. But it's all on display. I mean, their corruption is, when the media is reporting the corruption, it's on display. Because, and people know it. People are knowing about it and learning about it. And again, you know, several of these news reports talked about the victims. I don't, in air quotes, I'm saying victims. That's what they call them, and that's fine. That's them. I don't call them victims, though. Anyway, another topic. But you know how they didn't get to know either. I don't care that they didn't get to know. Could not care less that the victims did not get to know, or the accusers did not get to know about these secret meetings, because I don't think it, to me, it's not about them. these meetings were not about them. In fact, these meetings probably. Go ahead.
Well, except that there was also civil litigation going on. So
It's true.
anything that affects the appeal for the criminal conviction could also affect or could have affected the civil litigation that was pending at the time. So, yeah, in
Yeah.
fairness, their attorneys probably should have been told and allowed to attend, as well as Daniel's.
That's yeah. I mean, I guess that's true. That's a very valid point. Just, but I don't have to care, which I don't. I'm more concerned about what the injustice that was done to Daniel throughout all of this than I am about how it affects them. And I mean, at the end of the day, their appeal or their civil suit, they ended up dropping their civil suit anyway. So, but at the time, I get it. 2017, they were in the probably, I don't know, taking depositions. Who knows what was going on at that time. Anyway, so I don't know. I mean, for just in the chat, you guys can let us know if you want, or comment in the comment section or something. If you would like for us to read and record the amicus brief by these 6 renowned scientists, we can do that and read it for you and play it for you, play the recording for you, and because it's the points that they make in their brief, nothing there is gratuitous. Nothing in that amicus brief is gratuitous or untrue. None of these people really had any skin in the game, to be honest. They all knew of the case, and I don't know if Brett Turvey and Susanna Ryan, I don't know if they knew about the case yet or not, if they had, appeared with Michelle Malkin or not. I'm not sure of the dates, but regardless, that doesn't, the other 4 scientists who were willing to look at all of it and get involved, they weren't involved in the case at all. Brett Turvey and Susanna Ryan weren't involved in the case. They just appeared with Michelle Malkin to, talk about it. That's all that they had. So at any rate, all 6 of them, gave very, very highly educational and accurate information in that amicus brief. And it's if you're at all interested at all in DNA and forensic science and how those kinds of things work and all that kind of stuff, we'll read it and record it and play it for you all, and then you don't have to go and find it and read it for yourself. Sometimes we can be a little more entertaining than just reading it for yourself. So anyway,
I just pulled it out of the file. That's what I was digging for all that time. I'm going to sit and reread it. It's been a while since I've read it.
The amicus brief, yeah.
Yeah,
it's very interesting, and for the Oklahoma for the Court of Criminal Appeal, OCCA, to say that they to not even consider it or address it in the appeal or in their decision is that's just another indication to me that we're just going to leave that alone and pretend like it didn't happen, so we don't have to, because we don't want to address it because they make really great points. But that's just my opinion. I have no idea. I wasn't part of that. Nobody invited me to be a part of it. That's just because I have no education, but I do have a damn brain, and I do have, my own. I am able to think for myself, so I think that means something to me. Anyway, so Cherie just did a podcasts with Case by Case last night, and I was modding for them. And I was listening to some of the things that were being presented, and they were talking about DNA in the Delphi case. And anyway, I can't remember exactly what was being talked about, but I couldn't help myself. I wanted to, and I don't know if Under Your Scars is still here or not, but I side messaged Under Your Scars, even though I had been invited to drop the link to my own channel, and other links and things like that. I just felt weird about it. I was like, no, I don't want to, Besides that, nobody was paying attention, and none of the people in the chat were paying attention to what I was saying. But I was posting, or had Under Your Scars post for me, and I think I even posted it twice myself, if I'm not mistaken, with the timestamp, the Michelle Malkin's video with Susanna Ryan talking about, the female DNA, and is there DNA, in the secretions and all those things. That part of Michelle Malkin's video was very relevant to what they were talking about last night. I don't think nobody responded to me or to Under Your Scars when it was posted, so I don't think they were paying attention. But people should, everybody should, because it was very, very interesting information that Oklahoma State, the prosecution in Oklahoma, lied about, specifically Galen Gigger, in his closing rebuttal. In Oklahoma, in a criminal trial, the state, or at least this is how it was in Daniel's case, and I guess other cases. Daniel's case, the prosecution gave their closing argument. Daniel's attorney gave his closing argument, and then the state is allowed to rebut, come back in and do a rebuttal closing argument with after the defense makes their argument. And I get it. I understand why it works this way, but it really sucked in Daniel's case, because this is a video that we've already done and read and recorded and done a long, long time ago. If you want to hear the closing opening statements and closing arguments in Daniel's case. But in the rebuttal, Galen Gigger gets to do his rebuttal, and that's when he tells the lie to the jury about DNA coming from the vaginal walls of the minor female victim in the case. I don't remember his exact words, but he lied. Nonetheless, he lied, because as Susanna Ryan says, and Brent Turvey, and then all of these, this amicus brief will tell, that is not a thing. That is not testing that can be done. But Galen Gigger said it to the jury in his rebuttal argument. No objection was made, and it was a flat out lie. And we know from at least one juror who spoke to the media that after Galen Gigger said that to the jury in his rebuttal closing argument, that this one particular juror seems to imply that once Galen Gigger said that about the DNA coming from the vaginal walls of this minor victim, jurors were like, okay, that seals it then. If that's what these guys are.
His last name is Hill.
Speaks. Oh no, there were two. The one I'm talking about. So there was not Joe Hill.
Ron Hill.
Ron Hill, and then, but the one I'm talking about, his name is Daniel Speaks. Daniel Speaks.
Okay.
Yeah, but there's two of them. I'll redo that video for that news interview too, because he just, he talks about how that comes from, what's the name of the show, Cherie? It was Crime Watch Daily, I think, if I'm not mistaken.
I'm not sure.
Yeah, I can't remember for 100% certain, but anyway, Daniel Speaks, the juror, he appears on this news mini documentary that one of the news stations did. And he says that, yeah, well, they said it was from the DNA from the vaginal walls, or vaginal walls, as he calls it, which makes me cringe. But anyway, I creep out. I'm like, no! Anyway, he he says that, well, so that's what we went ahead and agreed to then. That's what they said in closing arguments. So he's guilty. And I'm just like, what? So anyway, I'll find that and redo that video, because it's the one I did was quite a long time ago, and it's very amateurish by today's standards that I have as far as video editing goes, and get it for you guys to see. Anyway,
I have thrown a fit about, prosecutors, especially in closing, throwing out these prejudicial, false things or statements. But I've heard judges or others justify it because, well, the jurors are instructed that what the lawyers say is not evidence. But come on, the average juror hears that and they don't think, oh, I'm not supposed to consider that because it's not evidence. You know what I'm saying?
Oh, I absolutely know what you're saying. Yes.
Mm-hmm.
It's like when the judge says, strike that last comment or that last word or that last statement or whatever from.
Oh yeah, I always love that. The jury will disregard that response. Yeah, good luck. All you're doing by doing that is making them stick it further into their brain.
Yeah.
Yeah.
Yep. The shit's out of the horse by then. You can't put it back in. It's already out.
Not
the bell's
cleanly,
been rung.
you can't. No.
Toothpaste can't go back in the tube. All those references apply to strike that or disregard. It's just silly to me. But anyway.
The other trick that I always love, and you see it a lot, used to see it a lot on Law and Order, is they would ask a lawyer would ask a question and the other side would object and they'll go, I withdraw the question.
Yeah.
Now, me as a juror, I'm going to go, okay, why did they ask that question and why did the other guy not want it answered?
Yeah. So why did he withdraw that question? And you know what? I think that's kind of that's just kind of human nature. We know that kids are like that. We know that that's how kids think and teenagers think. My mom doesn't want me watching this movie that has an R-rated. Why? Why can't I watch that movie that's got an R rating or whatever the case might be? Why can't I? Because then I want to see it, watch it, smell it, taste it, drink it, eat it more. When you tell me I can't, I want to do it more. Same concept applies with all of these things that happen in the courtrooms. So, but anyway. Oh, gosh. So that's what we wanted to share with you today. The kind of break down this, it's one thing for us to talk about the secret hearings and not really, and then just mention the appeal and the amicus brief and they did this. It's one thing for us to talk about that and say that to you, but to actually see those news clips with your own eyes and hear various attorneys talking about it, investigators and reporters talking about it, it makes it more to me it's more impactful in my opinion. So at least it is to me. And listen, everything I do for you is because I want it for myself. In a sense.
Nothing. Yeah, the judge allowed the misrepresentation to be spoken as a fact. The problem is, if I understand the rules of procedure in a courtroom right, the judge is not allowed to object himself to something that a lawyer says like that. It has to be the opposing party that objects. Daniel's lawyer never objected.
Yep. That's right. Yep. And that goes to what Rick just said. I'm pretty sure most or nobody in the chat is paying attention to the Lori Vallow Daybell trial, whatever her name is. I am because I've been, following the case since the children came up missing in 2019. But anyway, she's on trial now in Arizona. Lori Vallow is in Arizona for conspiracy to commit murder of her fifth husband, I don't know. Lori Vallow was a black widow, and anyway, she insisted on representing herself in this trial. She's a pro se defendant, and she's not as bad as Daryl Brooks was in Kenosha by a long shot. But Lori Vallow is she's got, I would say, I'm not allowed to diagnose anybody, but I have a lot of education and experience with people who have diagnosed histrionic personality disorder, borderline personality disorders, narcissistic of various different levels. I have a lot of experience working with those patients, and Lori Vallow suffers from, well, I don't know how much she suffers, but the rest of her people in her life suffer a great deal. Histrionic for sure, I feel like, and borderline personality disorder, and she's very manipulative. So as I'm watching her trial this last week, she's representing herself, and she's up against a prosecutor, but Lori Vallow cannot. I feel like she refuses to give up the control of what's being said and done and presented in her case, and I feel like that's why she insists on representing herself. But I think it was on Thursday, Wednesday, or probably all the days, the prosecutor is 100% leading every one of these witnesses that are on the stand. And this is what I was trying to get to with what Rick was saying. Everybody knows it. People who are watching it know it. People in the chat are saying she's leading the witness, objection to leading, hearsay. The prosecutor's getting away with all kinds of that shit. She's doing it. She's bringing in hearsay, leading the witness, irrelevant things. But Lori Vallow, representing herself, doesn't know when she should be objecting. And the prosecutor on a ethical side the other day told the witness, just answer yes or no, and then whatever the question was. Lori Vallow objected, objection, leading, and the judge said overruled, and she said, Your Honor, am I not allowed to object, whatever she said. And he said, well, she's not leading the witness. It's a yes or no question, was the response by Lori. And the judge said, well, she's just offering the witness a choice of what she can answer. And is that not leading? And the judge was he's very patient, one of the most patient judges. No, that's not leading. That's just offering the witness a choice of yes or no to answer. And so anyway, all of this leading and hearsay that's going on by the prosecution it's pretty gross, if you ask me. I don't like it in any case. I don't care how I feel about the defendant in a case. I don't like seeing this kind of misconduct by an attorney, by a prosecutor. It's disgusting and gross to me. But she's getting away with it because the defendant doesn't know when she should object or why. And she has what they call it an advisory council in Arizona. she's got an advisory council sitting next to her. It's not clear if she's called an advisory council. This lady's an attorney who was representing Lori initially. Can she not advise Lori, like nudge her, give her an elbow, object on this one, object. Can she not advise her? I don't know.
I was surprised at that too. And so either there's somebody there and they're doing a very poor job, or they're not allowed to if they are there. I don't know. I never had that situation.
Yeah, I don't know why she's not getting the advice, because I'll tell you, I think Thursday was the last. They didn't have court on trial on Friday. Thursday, the entire prosecution was leading and hearsay. And there was very, very few objections made by Lori. The one time she did try to object to leading, it was completely, the wrong context. So, so basically that's, but the judge is just letting her go. Why? He doesn't have a duty to, to warn the prosecution. So he doesn't. And why should he? Lori insisted on representing herself at the very, very, very adamant advice from the judge not to. She had to do it. She insisted on it. So I agree. I agree. There should be something should get said, but it's not getting said. But and it's gross to me that she's doing that the prosecutor's doing that and getting away with it. She knows she can get away with it because she knows that Lori isn't going to know. At least that's how I think about it. So I caught something up here that I want to make sure I talked about. This is about the Vallow trial. I thought I saw a question about something about why the Idaho case is not allowed to be brought in. I can't find that comment now or question, but whoever that was and whatever the question was, from what I understand, so Lori Vallow was convicted of murder, 3 counts of murder. Oh, thank you. Yes. Why isn't the Idaho trial allowed in? That sucks, as jurors don't know her past. Because they don't want, and I don't know. I mean, I guess I agree with this, honestly, to allow the defendant a fair trial. But if they did know her past, that would be very prejudicial. If they knew that she had been charged with murder, 3 counts of murder in Idaho, that just taints her whole trial, in my opinion. I despise Lori Vallow, what she did to her children, and Tammy Daybell and Charles Vallow, and probably that other husband,
Joe,
yeah, Joe Ryan, Alex Cox. I believe. I don't care what that damn autopsy report says. I believe that somehow, some way, they killed Alex Cox.
I do too.
Yeah, there's just no way it's a coincidence. There's no way.
I agree. If I was a juror, I'd be mad if I found out afterward. You mean she's already been convicted of so many murders and I wasn't allowed to know that? But on the other hand, I guess the rule is it's propensity evidence. Like she killed these people, she must have killed this one too. They want them to decide on the evidence, not on what she did in the past. But
right. No, she was not acquitted in Idaho. She was found guilty on all of those murder charges, and so was Chad Daybell. Chad Daybell is on death row for those. He was sentenced to death. Lori escaped the death penalty because it wasn't even a part of the trial, or the punishment, because of a some sort of clerical error that they claimed the prosecution.
Because prosecution didn't get a lot of the discovery in until the last minute, and that was their consequence. What a concept, a judge giving a prosecutor consequences for their misbehavior. Unfortunately, it's for Lori, but I didn't say that.
Worked in the wrong way, worked in the wrong direction in that case, right? So that's why they can't bring up Idaho. Now, Lori almost opened the door the other day with one of the witnesses. Was it Kay? Yeah, Kay Woodcock, Charles Vallow's sister. And they stopped the trial. They stopped it pretty, I don't want to say cold, but they kind of stopped it cold. And sent the jury out. And the judge said, "Are you sure you want to ask her that question?" And I don't even remember what the question was now, but Lori Vallow said, "Yes, I want to ask her that question." The judge told her, if you ask her that question and she responds, that's going to open the door to what happened in Idaho. Well, he didn't say those words, but those of us who know, we knew that's what he was talking about. And I will say this, the prosecution, if Trina Kay hears something that's starting to lean towards opening the door to Idaho, she does object. But the other day when Lori said, "No, I want to question her on this topic," whatever it was that Kay Woodcock was going to answer, the judge, any objection from the state, and Trina Kay, nope, no objection.
Oh no, I wouldn't object at that point either.
Yeah, bring it in. Let's bring it in, because if anything from Idaho does get brought into this trial, it's over for. I mean, it's already over for Lori. We all kind of know and believe that. Some of us are still like bizarrely stuck to watching it anyway. Anyway, but I only brought that up because of what Rick said. And how it does, play that way, that the attorney or that the judge, doesn't do anything to, say, to jump in and put a stop to that kind of behavior. But anyway, so anyway, it's just, it's a sick, twisted thing. I do watch this Lori Vallow trial. Karen Reed, call me sick and twisted. I can't wait for that. I just love watching live trials. I just think they're fascinating. I've learned so much from watching them. It's caused me to do research on my own about if it applies to Daniel in any way. I want to do more research. Well, how does this work for, in Daniel's case or whatever, or just to look things up and try to learn on my own, how, about different things. It's not a law education, but it's knowledge, and I am always trying to learn stuff. So anyway, all that, but anyway, this is all as far as these secret hearings. This is all that we have to share with you today for that. I know I wanted to go back and oh, have you? I should have known that, Liam. I should have known that. I didn't even think about that. I try to follow Nate Eaton just because I'm kind of loyal to him, because he's so amazing. He is like one of the most ethical journalists that I'm aware of. And so I've always been trying to be loyal to him. And, but anyway, I don't know why, but it didn't even occur to me. I can't hide that comment. I didn't even occur to me that Claire would be showing it. I'll have to try to check it out tomorrow. Anyway, that is it for this one. I really don't know where we're going to go next week. I'm not quite ready to start over yet with the beginning of the trial. It's going to take a lot of preparation and teamwork from my team, who I never asked for help because like I said, I always think I can do shit all on my own. But I can't. This is not something I can do on my own. I have to have these guys helping me to get ready to start this trial over. So from the beginning. And so, but we'll have something for you next week. Don't know what it's going to be. It'll be something. Maybe the amicus brief, the amicus yeah, the amicus brief, if I can get everybody together or a few people together to read, we'll read that, record it, and play it for you perhaps next Sunday. So we'll see what happens. If you have any other questions, I know there's been a lot of comments and I lied. I didn't mean to lie, but I didn't address everything like I said I was going to, because I want to kind of cut this off at this 2.25 hour mark at this point. But if you do have any other comments or questions, please, please, please put them in the comments section after the video's over. And no, I can't do it in 5. I can't do it in 5 voices. I don't have 5 voices. I mean, I can do it, but that takes a lot of editing. I know you are, and I'm so excited. I can't wait to have you read. I know Jennifer will be good for it too. So we'll get it organized and get it done. And thank you for being a member for 4 months. We appreciate that very, very much. Oh, wait, that reminded me. I did see one that. Thank you, Jennifer. I'm sorry, I almost forgot to mention this. $10 donation. Thank you so much. We really appreciate your support and your contribution and everything you're helping us do for Daniel's case. And so thank you so much. And then again, the 10 gifted memberships for More Here. Thank you both so much for your support for us to, helping us to get this stuff out to you guys, so you learn more, you know more about this case, this crazy, fucked up, corrupt case. So anyway, we will look at you, Cherie. I love that she can do that. Oh, okay. RP is game to read. His day off is Thursday. Cherie is usually off on Thursdays. Does a lot of her own personal things that she has to take care of, but perhaps we can put something together for Thursday. I'll see what Cherie's got going on, and Rick and Jennifer, and we'll perhaps get this done on Thursday. We'll see what we can do. That would be great.
I'm not really off. I just work out.
Oh, yeah.
So my time is flexible, usually.
I shouldn't have. Yeah, I apologize. I shouldn't have said she's off on Thursdays. She works from home on Thursdays. There's very different things. So anyway, so I'll get in touch with you, RP, and Jennifer, Cherie, Rick, and we'll look at, because it's a lot, so we can all take turns reading, certain sections or whatever. So there's plenty of content, to share the reading for sure. So we'll try. Maybe that's what we'll have planned for you guys for next week. Rick or Cherie, if you guys don't have any final comments before we let these folks go. No? Okay. All right. Well, until next time, peace out, everyone.